Harry, are you going to call the meeting to order today?
You guys are ready. Good afternoon. I'd like to call to order the October Board of Adjustment meeting. And if we can go into a roll call. Jan?
Here.
Our new member is Edie.
Edie Heron, yes, here.
And Mark Saunders.
Saunders here.
And Fred. Okay, and the missing is William, is it Perlman?
No.
Pearlstein.
Pearlstein, thank you. Okay. And is there any correspondence for the board?
I have not received any.
And we have no old business to go over, other than, I think, signatures at the end of the meeting for two of our cases, Fred?
That's right.
Okay.
Okay. Okay.
Okay, as far as new business, Fred, I want to turn to you. As far as election of officers, we do not have William here today. Is it okay if we delay the officer selection?
I think it's not just okay. I think it's probably advisable that you should have a full complement when you go ahead and elect your officers, and secondly, give the new members at least a chance to meet people and consider whether they want more responsibility than is minimal, or any other considerations they want to make.
Okay, thank you. And Fred, if you want to go over the rules changes?
So I do. I like the election of officers. I don't think it's advisable that today we vote on changing any of the rules. I'll just jump ahead and say I'm going to distribute the rules, and we can talk about the rules. They may give rise to other questions that you have. But the big thing that I'm hoping to accomplish today is just introductions, and then you've got my business card. I'd like to meet with you. We could perhaps do it here, but I've got offices in Lewis on the highway. I'd like to make arrangements with you to have a little orientation meeting, maybe two of you at a time if possible. And if we could do that in the coming week or two, I think we'd be better prepared for our first application. And we have applications in the in process. Is that right?
I have two of them.
Two. Mm-hmm.
So far.
So far. So we will be deciding cases or hearing cases at least in November, which will be about a month from now.
Would that be right by Thanksgiving?
I believe it's November 28th.
Yeah.
The Monday after.
Okay, all right. When I had spoken to Stan, he said that at this meeting, we might be talking about what the schedule would be, if it would remain as the fourth Monday at 2:30, or, and I don't know that that's true. I'm just asking. I'm brand new here to this board. Is that what we're?
Stan did mention that.
Will we be discussing some of those questions in new other business, or?
Well, actually, our rules indicate that we will meet on the fourth Monday of every month.
Right.
Okay.
And our present rules indicate that meeting is at 7 p.m.
Right.
Right.
So we haven't
Right.
updated the rules in a long time, and whatever we do need to coordinate with our town clerk, who staffs these meetings and has a considerable amount of responsibility with respect to these meetings. And then these gentlemen over here, they attend the meetings and advise the building official and make reports and presentations and answer a lot of questions that you're going to have in considering future applications. So their schedule needs to be taken into consideration as well. So I hadn't considered whether the date of the meetings would be moved.
Yeah, I did not consider the dates, and the time seems to be working for most of us. I mean, when we used to meet later in the evening, some of those ran really late. So I'm comfortable with the fourth Monday as well as the time.
As am I. I wasn't indicating that I wasn't. I was just, it was a question. Yeah.
And I know the reason that, you know, when I was appointed, it was 7 o'clock. Well, actually, it was COVID. So it was on Zoom. And I had a conflict, two meetings at the same time, and one meeting moved earlier and this one moved till 2:30, and I can drive back and forth. So it works for me now.
It works for me anytime, really. So.
I think Stan's request also is to make sure we all know that it's the fourth Monday. And we usually hear from Ann, I guess, the first week or right before the first week of the month, whether we have a case or not. So we get that heads
Now,
up.
also in December and May is when it's Christmas and it's
Memorial Day.
Right.
So the fourth Monday may create a problem. It will this year.
Right.
So generally what has been done in the past is the meetings have been backed off to the third Monday in December and also in May, if there's a conflict. I know there's going to be a conflict with Christmas.
I can look at May here, 1, 2, 3. Actually, the fourth Monday in May is the 22nd, where Memorial Day is the 29th
Okay.
next year. So that would
May
not,
would be fine.
right, but you're absolutely,
I'm concerned about, December coming up.
Okay.
yeah, it would be 26th if it were held on the fourth
We
Monday.
have a holiday.
Correct.
And I can tell you right now, I'm very rarely here because my children all live in Florida, and we have Christmas with our kids. So hopefully nobody will have a case for us on December 21st or whatever.
Or we could just change it.
Oh, I think there is going to be a case in December.
So are we aiming for the 19th? Is that what we're saying?
Yes.
Monday, the third Monday? Okay, just in December, okay?
Has there been any discussion of continuation of virtual meetings in the city? Not just for the Board of Adjustment, in the city?
I did have this conversation with Glenn.
Yeah.
I can respond to that. So the mayor set the policy after COVID that he preferred in-person meetings. The statute, Fred, you probably know, the statute does provide a weird caveat that if a member has a mobility disorder, that we have to provide accommodations for that virtually. I was sort of anticipating that the mayor might relax the standard a little bit as time went on. He has not at this point. He prefers in-person meetings, and there's value to be had in person, but also when people are traveling, I understand that side of it as well. But as of now, there hasn't been any indication that we're going to move to a more virtual platform.
Okay. And that would only be on an as-needed basis, not virtual, across the board,
Well, a number of the beach communities, and Glenn is associated with a couple of them, and so am I think they are, well, they have a built-in challenge. A lot of people do leave town and go to the beach. A lot of them have non-resident members of these committees who come over on weekends. So they like to have a lot of their meetings on weekends and after hours. So it's not as big of a problem for many of the other communities up and down the state as it is for these beach communities to get people here in person. I think that there's also, though, that Glenn mentioned that there's value in being here in person. I mean, you are acting as judges, and I think there is benefit to witnessing in person the testimony that's offered. So I think there is some bias against doing it remotely. The fear is, I think, that it would become too easy to attend the meetings but virtually if you're given the choice. Boards of adjustment are have a lot more responsibility than some of these other committees that are also doing important work, but I think there's a desire for those who might want to appear before them that they appear in person. So there are arguments on both sides.
Okay. And are we technically able to do split? Members meet here, and if one person is absent, bring them in? I don't think we have that capability here, do we?
Yeah.
Oh, I think we would probably.
We would? Okay.
If you were allowed, if
If it
the
were
rule allowed for attendance virtually, then I think we
Okay.
could probably do it through a Zoom.
Okay.
one or more members under that circumstance could participate that way.
When Stan was interviewing me, he was pretty adamant about in-person. He
He's
said
very
if-
adamant.
Yeah.
So, I mean, I'm just
Yeah.
throwing that
And
out, not
The
with any.
state allows it now. They didn't, FOIA didn't before, but they allow it now. But Stan is very adamant, but there are circumstances.
Me especially?
Yes,
Me?
yeah.
All of us?
Okay,
Okay.
all right. Well, I
Excuse
thought I-
us
I
then.
thought I
Sorry.
had my
Thanks for
microphone
letting us
pretty
know.
close. All right.
May I ask a question back to what you were saying about having an orientation meeting with you? You're saying the members of the board here. So two of us at a time.
Right.
And what's the best way to, do we call you and do that, or do two of us choose and you say a day and time, or?
If you would just indicate to me either, you've got my email, you have my
Yeah.
phone number there.
Okay.
I'm in the Lewis office, though I have Dover information and Lewis information on that card. You can use the Lewis information. Give me a call or send me an email, and once I hear from a couple of you, then we'll make arrangements.
Are there any days or times of day that are better for you in general, like not Wednesday in the afternoon, or not Friday in the morning or something?
Not really.
Okay.
And I really appreciate Fred doing this because
Yes.
I never had it. You know, I just kind of walked on and that was it. And just in the conversations that Fred and Barry and I have had recently, it's been a great learning experience, and I look forward to learning more.
May I ask a few other questions?
course.
When I was reading over the rules that I had, the most common one, but I guess we'll be discussing those later. But I also read in preparation the Delaware Code that had to do with boards of adjustment. And in paragraph 327, they're talking about that there's an officer who grants a dimensional variance for existing conditions that do not exceed 1 foot. And it seemed to, what it's saying to me, if I understand it correctly, is that the board, that the officer, the building inspector, I guess, or has that latitude to adjust anything up to 1 foot, but anything over 1 foot has to come to the Board of Adjustment. Am I reading that correctly?
So this is the state code that you're
Yes.
reading from?
Yes.
And this is where this board gets its jurisdiction from?
Yes.
The state code also authorizes the municipalities to adopt their own standards
Oh, okay.
for allowing what we refer to as administrative variance.
I see.
And the city has adopted a standard for fielding administrative variances.
Right, the city has, it's been, Ann, maybe a year and a half, 2 years ago, that the administrative variance ordinance passed? We didn't have it for a long time, and it is only for setback encroachments. It can't be a height issue, it's only a setback. And I don't remember, did they grant the full 12 inches, or was it something shorter than that? I think it's 12 inches. I think that's right.
So they essentially chose, they used what the state had in
They-
place already?
That's right.
Okay. All right. Well, that was just a question.
We used to have cases where somebody would be putting siding on their house, and they were a commercial, sort of built to the edges or whatever, and the siding was, a half or 3/4 inch thick, and that was an encroachment, and it'd come before you to decide it, and everybody was like, why are we hearing this?
see.
And so finally, they adopted an ordinance that would allow the building official to grant those
see.
sorts of things.
And Glenn, correct me, they don't have to come to the Board of Adjustment. The building inspector would simply deny it over 1 foot, right?
Right, that's right.
right, but that's the only recourse.
Yeah.
If it's denied and they still wish to
Right.
follow through. My other question is, I attended several Board of Adjustment meetings in anticipation of perhaps being named here. And one of the things that you folks spoke about was the 4 quick check. And I couldn't find those written anywhere. And I'm wondering if there's a way for me to get the wording of that.
So my
I asked
next.
Fred if he would give it to us.
Right, so my next thing I'm going to hand out in a few minutes is a very brief recitation on the quick check standards. And they're important for you to know, but they're also important for the applicants to know. Sometimes applicants aren't represented and they don't know how to make their case. And oftentimes we have people in the audience and they don't know what's really relevant to your considerations and what isn't. And they might want to come in and talk about how they don't care for some of the activities that go on at the neighboring house, but that would be something that, it could be, items could be raised during the course of a hearing that you would nicely entertain, but then dismiss from your deliberations.
I
So
see.
it's important to be able to distinguish between those.
It seemed to me that those became the litmus test for making a lot of the decisions that you were making, and they made a lot of sense to me, but as I said, I couldn't find them written anywhere, and so if you're going to distribute them, if I've jumped the gun for your agenda item, I'm sorry, but
Well, we
I wanted to be
wouldn't
sure
want to
that
do
I had them.
anything that makes lawyers obsolete in the process. We're hiding
Okay,
all
all
that
right,
stuff from
okay.
you.
Spell quick with a K.
Right, yes.
It's like if you lived in Florida, it's a grocery store chain, Quick Check, KW.
So I will pass those out.
Okay, great, thank you.
And your jurisdiction, since you brought up Title 22,
Yeah.
includes
I read all this.
appeals as well. But the primary cases that you're going to hear are going to be requests for relaxation of area, or what we sometimes refer to as bulk standards. And that's where the quick check rules come in particularly handy. There is a category of variances, I'm going to get in trouble with the guy if I lean back too far. There's a category of variances called use variances, and we're not going to talk about those a whole lot until we're presented with one. And at that point, I don't want to confuse you in our next, meeting or orientation with those considerations.
Fred, I have yet to see a use case, I think, since I've been on the board. If we do get one scheduled, is it inappropriate or is it appropriate to allow us to discuss or get some guidance before, not to talk about the case, but to,
Absolutely.
Okay.
Yeah, I think are they permitted in this jurisdiction? Is there a prohibition against it?
No prohibition.
Yeah,
against use,
right.
yeah.
So, that would be typical that there wouldn't be a prohibition, but essentially what you're saying is that I can't make any reasonable use of my property given its present zoning district
We
designation.
had one, actually, not when I was on the, a long time ago, when I was a city commissioner. And it was right up at the top of Columbia, and right just down from the motel, the Prince Motel. And they wanted to have a beauty shop in their house. And so that was a use. It was a residential, and they wanted to have a beauty shop in it, which wasn't allowed. And I wasn't on the Board of Adjustment, but it was,
I'm guessing that was denied.
Do you know? I can't remember. Do you remember that one? Well, no, you weren't here then. It was Walt. It
No,
was
I've
Walt
heard of it,
Speakman.
but I don't know if I ever knew the outcome of it.
It was in the, I can tell you, it was probably 95, something around there. And I cannot, this is awful, but I think they did get it, but I don't remember because I wasn't on the Board of Adjustment and,
So there are categories of uses called conditional uses or home occupations that sometimes are recognized in the code, and sometimes applicants are authorized to seek that type of permission or permit from this group, or sometimes it's something the Planning Commission can make a recommendation on. But I know there's no such use going on Henlopen Avenue right now.
no, this is top of Columbia,
Columbia, well,
right by the Prince Motel, just
Okay.
east of the Prince Motel. The
okay.
house is still there. It sits kind of on a funny shaped lot, but I
But
just don't
rather-
remember back that far.
So there are such things, but I certainly wouldn't want you to start to fill your head with those minority-type considerations before we get real comfortable with the ones you're going to be applying on a regular basis. So, Edie, you attended some meetings, and you might recall that when Jerry was the chairman, he would read an abbreviated statement about those quick check standards, and since you brought them up, I'll go ahead and read to you a statement that we read at the Kent County Board of Adjustment before each meeting. And then again, I'm going to hand out a little bit of a worksheet that I have that relates to this, but it says that the test for the granting of area variances is set forth by the Delaware Supreme Court case known as Board of Adjustment versus Quick Check Realty. The legal standard for area variances considers whether a literal interpretation of zoning regulations results in exceptional practical difficulties of ownership. And to determine whether the exceptional practical difficulty test is met, the board must consider the following 4 factors. First, the nature of the zone where the property lies. Second, the character and uses of the immediate vicinity. And you don't need to write this down because I'm going to hand
Oh,
this
okay,
stuff out.
great, thank you.
Whether removal of the restriction on the applicant's property would seriously affect neighboring properties. And all these words are really important. So seriously affect is not the same thing as saying, would cause significant harm to. We can talk about those things when we meet. Fourthly, whether failure to remove the restrictions would create unnecessary hardship or exceptional practical difficulty for the owner in relation to the owner's efforts to make normal improvements to the property. This factor is met only when the difficulties alleged by the owner are practical rather than theoretical and exceptional rather than routine. The inability to improve one's business may qualify as an exceptional practical difficulty. And this is also the consideration where the board decides whether the applicant is seeking more relief than is minimally necessary to relieve the difficulty. So you're generally not going to be considering any factual representations that can't fit into those 4 categories. And you're particularly instructed not to take into consideration any discussion of animosity between any neighbors and the applicant, as you're not authorized to deal with those things and should not let that creep into your consideration.
Is there any homework that we should have in preparation for our meeting with you?
So there's 2 of those statements for you, and there's 2 for this side of the table, and I'm going to make copies of this stuff and send an email to Mr. Perlstein either later today or tomorrow morning and introduce myself to him as well. There's a tiny bit of fleshing out of these concepts on this sheet of paper, but most of this you're going to have to develop a feel for in the course of our discussions and as you prepare for upcoming applications. So as far as the rules are concerned, as far as the first item on the agenda, 5A, again, I think it would be nice for you to consider whether you want some responsibility. You could report that to me, and I could share that information among the other members. And of course, Jan and Barry are both welcome, not welcome, but encouraged to schedule a meeting with me as well. And we can talk about who might serve or who would like to serve in official capacities for the board. And then regarding the rules, we've gotten some suggestions, some outside suggestions for our rules, and we can talk about those in advance of the next meeting. What I'd like to do is do a marked up version of our current rules with some proposals inserted and highlighted so we could consider them at our next meeting. There is a reference in these rules to our meetings being subject to the Freedom of Information Act. Our town clerk plays an important role in complying with the notice requirements for the meetings, and we will talk when we meet about the importance, or at least the acknowledgement of the application of that act to your conduct. You are now, by virtue of accepting your appointments to this board, you're in, at least with respect to this board, you're public officials. Any conversations that you have regarding pending public business is fair game for people who would like to know what you're communicating about via email, for instance. I'll talk to you about that when we meet. You may, it would not be appropriate for you to communicate with one another during the course of, or between meetings in an effort to try and influence the outcome of a pending matter. I will be asking you not to reply all. If I send an email out, or if somebody sends an email that has all of you on it, try and remember to reply directly to whomever is soliciting a response, as opposed to replying to all, and keep those considerations in mind going forward. You are actually sitting in the position of quasi-judges, so you wouldn't expect that an applicant could talk to a judge before his trial or during his trial, and you need to observe the same kind of rules as a judge in these matters. We'll talk about conflicts of interest, what is an actual conflict of interest, what might look to the public to be something that doesn't reflect well on the board if you remain involved. Generally speaking, the public is quick to accuse people of acting in a self-serving manner, or despite the existence of a conflict. It's very often not the case that there is an actual conflict. And you do have a responsibility to serve as well. It is it's nearly a no vote or could be considered a no vote for you to recuse yourself, especially if it's unnecessary, because an applicant needs needs 3 votes. That's what our rules provide in order to get a decision of the building official overturned, or to get relief from a zoning requirement. So if we've got 3 people present, and that's all we have to work with, that means the decision has to be unanimous. And that might be considered by the applicant to be unfair, that they can't get 3 votes out of 5. They've got to get 3 votes out of 3. Sometimes we will offer to applicants the opportunity to continue their matter to a later date if we've got less than a full quorum.
Fred, if we have questions on that, we can reach out to you to say whether, should we recuse ourselves?
Absolutely.
Yeah.
Yeah, absolutely. And that would be that'd be very typical to field questions like that from members of a board.
You know, as you're aware, it's not a secret, I recused myself from the Bellhaven because I'd already taken a position against it before I was on the Board of Adjustment. But, there's also the State Board of Ethics, because I think, was it you and I had a conversation with them about another, I can't even remember what it is now, but they're always there, and because anything that gets, that if they file an ethical complaint, it goes to the State Board of Ethics, because that's what this city is covered by. And they're very helpful in helping determine, whether you need to recuse or not recuse.
So, exactly, and I was going to raise that in further response to Barry's question, because if you think you're not going to like the answer, or you don't like the answer that I've given you, or if you just want to go directly to the Public Integrity Commission.
Oh, I couldn't think of the name,
Yeah.
that's what it is, yeah.
You are more than welcome to do that, and by the way, I won't feel one way or the other about it. If you feel you want to start with them, the benefit of going to them is if you follow their advice, then you will not, you can't be the victim of some kind of a citation that would come with an allegation of violating your ethical responsibilities to the board.
Fred, is there ever a case where you would ask the applicant whether or not they feel comfortable with you reclusing yourself or not?
I don't think so. It's an interesting question. I can tell you that there are, I'm sure it's happened, in fact, I think it's happened fairly recently, that an applicant has felt as if there was a recusal when there didn't need to be a recusal. And as I said, if you've got one absent and one recused, the applicant feels that they're disadvantaged, so they don't, you are not encouraged to recuse yourself. And sometimes you might feel like this is a particularly hard decision you've got, you're faced with, and you might like to recuse yourself to avoid having to exercise your authority. But that is, that's to be discouraged. And you're only to recuse yourself when it's justified to do so, and that's not always a black and white question. We'll talk about that when we meet as well. In the end, the question is, can you perform your responsibilities in an unbiased fashion if you don't have an actual conflict? If you've got an actual conflict, you have no choice but to recuse. But the class of those conflicts is probably more narrowly defined than you might think.
You go over those when we meet.
Yes. I will. And then none of the conversations that we're going to have in the coming week or two is a conversation we can't have again. So I realize that you all are, this is not the only thing that's going to be going on in your lives. And if we need to meet a second time, or however many times it takes, we need to talk on the phone, you're encouraged to give me a call. I would rather hear from you than not. All right. So some of the rules I think that we're going to be examining, again, are going to be with regard to our start times being at 2:30, and whether you want to adjust that or need to adjust that somewhat. Provided that works for everybody, we can do it. We have to have this room available, so I don't think we have much flexibility in terms of choosing another date. I think that's probably going to be too big an ask. So rules of order sometimes are mentioned during the course of a meeting, and you'll notice that we have a section 10 or Rule 10, which refers to rules of order. This board does not officially adopt a specific rule or set of rules of order. You've heard of Robert's rules. You may have heard of Mason's rules. We try and apply the rules in an effort to have an orderly meeting, but we're not going to get hung up in rules that interfere with our ability to be efficient. You should not be made to feel like you need to study the rules of parliamentary procedure in order to be a member of the board. That's asking too much. There might be times when we would consider different motions, a motion to table, a motion to reconsider, and I can help walk you through those scenarios when they arise. Any other questions? No? Nothing that's on the tip of your tongue? So what have I handed out? I've handed out,
You handed out rules and the quick
rules.
check.
Okay.
Two things,
right,
a one-page and a multi-page.
yeah. I think that's all that I had. One thing.
Could I ask one thing?
Sure.
One of the things that that when we have, and I don't know what the cases are coming up, Ann, some of them are pretty perfunctory, not perfunctory, but they're small, they're simple cases.
Routine, yeah.
Thank you, routine, that's the word. Is that when things go on for a very long time, more probably than, what, 3 or 4 hours, it becomes probably not very, can you postpone, can you say, we want to continue this, like, and because it's been 4 hours and we haven't reached a decision yet, or something like that? Are you allowed to have a part 2 of a meeting?
Continuation.
Thank you, continuation, yeah.
So we're going to endeavor to do what we can to prevent you from being in a situation where we have one application that takes 4 hours. But at the same time, you could be presented with something that it was going to require your attention for a lengthier period of time. And if there is a big audience and a lot of people want to be heard, and there are certainly examples of that, it is something that can be, it can be considered that you might move to stay or continue the matter to a subsequent date. Now, the difficulty there that you'll each feel, there's going to be pressure on you. I mean, you might go to cocktail parties, you might go to restaurants, you might see people who have an interest in something that's pending before you. And once the application is made, that pressure could be turned up. And obviously, it's going to be important for you to be able to say, I can't discuss that with you. And I appreciate your interest in the topic, but I am forbidden from discussing it between meetings, because when you ultimately make a decision, your decision has to be based on what's in the record. And what's in the record is what comes in during the course of the meeting. You're certainly allowed to take into consideration that the sun comes up in the east and sets in the west, and there are things that we call judicial notice that you're allowed to take note of, but it would be, I would strongly discourage you, I would ask you to be very careful if you're going to rely on statements that are made, that they're statements that were made by individuals in the course of the meeting. Anything other than what is, that makes its way into the record, the applicant or the city should have an opportunity to respond to. And if they don't know what it is that you're going to base your decision on, then we're in trouble.
Yeah, I have a question after Jan.
So that if somebody from the audience, that's part of the record, though, any testimony that's received during the course of a meeting, so that, and then.
So long as it's relevant.
Right, right. I mean, the fact that, they vote in every election is not probably relevant.
Right. Or I've lived here for a long time. You
Right,
get that a
right.
lot, right.
And once a case is closed, are we then allowed to be a little bit more able to discuss?
So you're not prohibited from discussing a case once it's closed, but what does it mean for a case to be closed? It might be not only has the case been decided, but has the written decision been issued, and that should be done in 30 days. Sometimes that doesn't get done in 30 days. And then has the appeal period run? Because if you communicate after a meeting some thoughts which are arguably inappropriate or rationales which are not viewed to be appropriate, they could be discovered, and there might be an effort to attack the decision based on some inappropriate consideration of an individual member in a close case. So,
As far as one case setting a precedent for another, we'd be able to discuss the case A, for instance, if we thought it was relevant to case B in this room.
So we'll talk about precedent when we meet. Precedent is a gnarly subject for boards of adjustment. We issue written opinions, but they're not opinions that end up in volumes that parties before us are supposed to consult. And so you're a little bit of a different body in that regard, and we can talk about the nuances of that.
Yeah, Fred, I had a question, and I don't know whether you can answer it here. When I see, the quick check, especially in the exceptional practical difficulties, I look at the request and I look at code. It's, for me, that's how I weigh things, right? But when we see things in the past, it's happened without going into specific cases, we hear a financial exceptional practical difficulty. We do not, as a board, discuss applicants' finances. And I had a tough time on one recent case on that, that's an accepted, and could you give us clarification in the future on what that word, what that financial means? Because it's difficult. I don't know if you can talk about it or,
Well, the quick check case, one thing you should know about the quick check case is it involves a business. And the finding was that the business was trying to stay competitive and needed a relaxation of an area requirement in order to stay competitive.
so it's competitiveness would lean in that direction, or could be,
Right, so, but
okay.
that's for a business.
right?
I don't, there's nothing in those four considerations that says that an applicant's, or the financial hardship associated with compliance is either to be disregarded or is recognized as
Just have
a
to
winning
You just have
argument
to
either.
weigh it.
So
Okay.
you're gonna have to, now, if somebody comes in and says they have an exceptional practical difficulty, and the difficulty is the cost of removing or moving illegally or unpermitted improvements from being made, then that's not a very strong argument, and that relates to finances, it relates
Right,
to
okay.
cost. But if somebody says that they've got if somebody makes the case they've got an irregularly shaped property, and it would be very costly to install a normal improvement, and it otherwise meets the other tests, I think
Okay.
the cost factor can be an element in
Okay.
your
That helps.
considering.
This helps. Okay. Thank you.
You know, we recently had a case by Central Park, and a few years previous to us, on the opposite side of Central Park, the Board of Adjustment did not grant a variance for the exact same thing and made them remove. So I've always been told that precedent is not, the cases don't impinge on each other. Each one is seen as a standalone case. Because if that wasn't the case, then we would have, you would have probably had to research every case that happened, around Central Park or whatever.
Right.
So is that still the case, is that each one stands on its own merits?
So each does stand on its own merits. The applicants are each making their own argument as to why they have an exceptional practical difficulty, and each of the properties that they own can be distinguished from the other. The location of an encroachment in the vicinity of the park on one side might have a more significant effect than it would have on another side of the park. I don't know, but I do know.
Well, it's a whole different Board of
Yeah,
Adjustment.
one thing, and it's an entirely different Board of Adjustment, and you're not here as, again, the decisions that this board makes are not reported in such a way that they can be researched. So
Okay.
they are, in that very technical sense, not establishing precedent. And you're you're not beholden by decisions that were made by prior boards.
Yeah, I didn't even know about it, but afterwards, somebody who was there, 10 years ago told me about it. So,
Yep. So, anything else? Well,
Nothing further from me.
I want to welcome you all, and again, I look forward to meeting with you in person. We'll get those scheduled as soon as possible, and we'll get ready for our responsibilities.
Would it be helpful, Fred, if we just gave you our emails while we're here?
What would be, if you, since you've got my email, I would ask you if you send me an
then you'll have it
email,
fine.
and then that way I'll be able to find it more quickly than if I write it down.
And would you prefer, like, if Barry and I came together and Mark and Edie came together, or do you don't care?
I don't care. I
Okay.
think that if you all just indicate what your availability is, then I'll mix and match, and
Okay.
we'll spend some time together that way. All right?
Okay, any other business?
Anything from Ann? Anything from Glenn and Alex?
You know, there is one cautionary note that I would, since it's new members, you know, on an appeal, not so much a variance application, but on an appeal, you know, it's the applicant questioning the building official's interpretation of the code. And I feel like sometimes previous members, none that are up here now, would sometimes give deference to the city building official. And it's his job and my job to be as persuasive, more persuasive than this team if you're gonna vote on his interpretation. So I just caution you not to be deferential to him because he's a city employee that we all know and like. But it's our job to make our case, just like it's the applicant's job to make their case.
That's particularly nice to hear coming from the city solicitor. And that's completely accurate. So you shouldn't feel like you're pressured or carrying water for, you know, in order to earn your keep with the board, you've got to adopt their view of the world. The state code, which you brought a copy of,
Yes,
the state code specifically authorizes you to have the last word on interpretations of the zoning code, and there's a long history associated with that. You know, there's no perfect system for dealing with these scenarios. This is the best we've been able to come up with, and we'll work our way through these situations as they arise in the future. Thanks for that. Appreciate it.
Thank you. Okay, we'll put you to Mark and Edie, put your work. Will someone make a motion to adjourn the meeting?
I move that we adjourn the meeting.
And there we go. Thank you. Meeting's adjourned. Thank you.
Thank you very much.
All right.